Hi, everyone. Welcome to episode 56 of the Immigration Lawyers Podcast, covering August 21st through September 3rd. This is a 2-week period because I wasn't able to do a podcast last week. I was moving homes and it was much more work than I expected it was going to be, so I couldn't actually do the podcast last week, but I'm glad to get in it this week. It was a crazy time to not do a podcast because President Trump went all out and did a lot of different things affecting the immigration field and immigrants and the whole U.S. immigration system. Today's Labor Day. I wanted to hope everyone's having a good time taking a break before we jump into it. But without further ado, let's get it started. Welcome to the Immigration Lawyers Podcast. I am the host, Attorney John Khosravi, and I practice U.S. immigration law exclusively. For more information about the program, please visit www.immigrationlawyerspodcast.com. Please note that this recording is informational only and does not constitute legal advice. Please consult with a licensed attorney for specific legal guidance that suits your case. Also, this recording is copyrighted and written permission is required for rebroadcasting. For more information about me, please visit www.jqqlaw.com. The biggest news that's affecting the immigration story in the news is President Trump's decision to remove DACA. Now, the exact wording hasn't come out yet. It's probably going to come out this week. But from what they're saying is that DACA is going to end, and they're going to give like a 6-month period of time for deferred action to be able to be phased out. During this period, there are some senators that have introduced a DREAM Act Light, a conservative version of the DREAM Act, because I think they understand that by removing DACA, it leaves a lot of people under a lot of pressure, and who knows what kind of consequences will come about. So hopefully in the Congress and the legislature they could get something together to help out people and have a path to lawful permanent residency for those who came as a child and haven't had criminal history and all that kind of stuff. But we'll see what happens. One of the things about deferred action that was very helpful for a lot of immigrants was that if they were able to get advanced parole, leave the United States and re-enter, that re-entry could allow them to adjust status. For example, if they had immediate relative petition for them, for example, marriage with a U.S. citizen. And USCIS says about 40,000 DACA applicants and DACA recipients were able to get lawful permanent residency through this route. This caught the attention of 2 senators who have asked the government and are doing research as to why what they consider as a loophole is permitted for DACA applicants to have a path to eventual citizenship. Now, it's not too complicated, but I guess people weren't aware of it. 40,000 is relatively a small number compared to the large number of people who are here unlawfully, but there's more attention to this fact. So we'll have to see what happens with that. I'm not sure how easily they can undo that advanced parole loophole, as they call it, but they are putting a lot of attention on it. Now, a lot of people had come to me when they had deferred action, wanting to adjust status based on marriage to a U.S. citizen, and the advanced parole route was there, and many people, as USCIS says, 40,000 people took advantage of that. But for that 40,000, I would imagine there's probably 100,000 or more people who are too afraid to do advanced parole come back in because of the border situation and being stuck outside the country. So a lot of people didn't take advantage of it. I actually had a person contact me yesterday to do it, and I said, listen, I can't trust this administration enough to risk applying for advanced parole, having you leave and then not come back. Now, other practitioners might think differently. I might be wrong, but it was just too risky for me to take on something like that, especially the amount of time it will take to process it. Unless there's like an emergency advanced parole situation you could do at the USCIS field office, and there's good documentation of facts. Relying on USCIS to approve it, and then in the middle of the way things not falling apart is just too much to charge someone and get a fee for that. So I wasn't. I told them I wouldn't do it myself, but it's a little too late. Now, Trump is also pushing USCIS to make, Trump and his administration that is, to make the extreme hardship standard for waivers more difficult. They've also begun denying advanced parole in adjustment of status cases if the applicant had an H or an L or a K3 visa, left the United States and wanted to re-enter. Normally they wouldn't just deny the advanced parole, because if the person had an H or L, these kind of dual intent-ish kind of visas, they were permitted to re-enter with those. They could still do that, but now they're actually denying the advanced parole as well, whereas before they would just let it get approved and wouldn't affect the case in general. Now, if you have an H visa and you travel, you can come back in while adjustment status pending. That's not an issue. But in some cases, the person may have changed status to H, or their H visa might have expired, so if they leave the U.S., they have to go to the embassy, get another visa, and come back in. When there's issues like administrative processing that can take months sometimes, it can create a lot of dysfunction for someone who has a job here, who has a family here, to go and wait for that visa. So In that case, unless advanced parole is issued, I wouldn't take advantage of the H visa status or H status to travel and come back. Not worth the hassle unless there's an emergency. The second biggest, and if I did this podcast last week, would be the biggest, is the decision by President Trump's administration to force EB employment-based interviews for every single employment-based case. Now, this is a terrible decision. They used to do this all the time. It's been a decade or more that they have been doing this. Only in rare cases would they do interviews for employment-based applicants. And I think it's a horrible, horrible idea. Already, as it is, USCIS field offices don't have enough employees to handle the interview. So we're waiting months and months for naturalization cases, months and months for marriage cases. Those are a little faster in some areas. For example, Los Angeles, I'm getting you as quick as 3-4 months. But in Vegas, I have cases that are waiting 8-10 months for a marriage or a naturalization case or more. So this is just going to delay things more until they hire people, if they hire people and train them. It's going to be harder. And then that goes to training. It's hard enough getting officers who are very adept and knowledgeable about the marriage type cases and the naturalization cases. Because of the myriad of legal complexities involved in this, it takes a lot of time to study. And it's not just the officers. I don't want to blame them. Even lawyers to learn this stuff can take a while. If you want to add employment-based from EB-1 to EB-5 categories, the perm process, judging what extraordinary ability is and getting into that, which they will, re-adjudicating the I-140, even though they should focus on adjustment stuff, it's going to cause a lot of problems, a lot of additional delays, a lot of additional RFEs. It's just going to be a terrible, terrible issue. So I think this was a very bad idea to do this. USCIS already has methods of checking fraud on these cases. They work with the Department of Labor and do all this kind of stuff and on-site inspections, all that. I don't see what is necessary to do an interview in most of these cases. As before, if there was even an inkling of a fraud involved or a perception of fraud by USCIS, they could always call them in. But to do an all-out interview requirement, I think it is intended to just bog down the system, make it more difficult for people to stay in the U.S., adjust status, and live their lives here. So that was another terrible decision by the administration. There's also hints that they're going to be cracking down on the J visa for people coming here on a temporary, cultural exchange process and working here. So that's something that's going to be coming up. Also, anecdotally, I've been hearing that H-1B RFEs are on the up and are rising, and a lot of people are getting RFEs, especially for people that are on the lower end of the pay scale. They're cracking down on what the job is, what the specialty occupation is, and what their payment is going to be for their salary. Now, on to immigration court decisions. Part of a SB4 sanctuary city law that was passed in the state of Texas was overruled by a federal court judge. They're essentially forcing law enforcement to crack down and do local law enforcement doing federal immigration processing and asking people about their background. And the courts pushed back on that and to avoid forcing local cops to enforce federal immigration laws. Also, in the Ninth Circuit, they overturned a removal order for a gentleman from Hispanic background because the Coast Guard had spotted them, and just based on ethnicity alone, allegedly or apparently, they put this person under detention and sent him to removal proceedings. And they said you can't just base this kind of detention and initial apprehension based on someone's race and questioning on that. There has to be more to it. So that was an interesting case. President Trump's administration settled the case that was related to a lawsuit from the first travel ban. In that settlement, they are reissuing letters to people that were denied admission saying you can reapply for admission. And the first travel ban was a mistake and we did it wrong. You could redo it again. So I don't know. I'm not sure how many people that affected, especially because the second travel ban will maybe stop some of those from happening. But the lawsuit did push back on them and they did settle. One of the most horrific parts of this crackdown has been that ICE has been enforcing itself in California, for example, in the courthouses. So when when immigrants or unlawful immigrants enter courthouses for civil and criminal proceeding, ICE is there ready to pick them up. The California chief judge said this is in full swing and they're still doing this. And in general, their statistics show that ICE detainment has spiked more than normal. Now, this is all in line with the mentality the administration has towards immigration. President Trump pardoned Sheriff Arpaio of Arizona, who was cracking down on Hispanics in his jurisdiction as well. President Trump's State Department has also said it may sanction 4 countries that have not been receiving or accepting people that are ordered removed from the United States. So they're going to potentially enforce non-visas for citizens of those countries until those countries adjust their rules against accepting deported immigrants to the U.S. I don't think they've made a final decision on that yet, but that's the word that's coming out. There was another case where someone sued USCIS for unnecessary delays in cases and slowdowns, and the judge threw out that case. It said, no, USCIS has been doing things according to their regular plans, and there's no issue involved. And if you've been practicing, and I discussed earlier, delays are all over the place in immigration processing, more than usual. I think everything's about 30% longer to do, unfortunately. Finally, in the news, USCIS has issued a statement partially holding the state of Vermont responsible for the EB-5 debacle they had there with their regional center. And I agree with USCIS. The problem with having a regional center for EB-5 immigrant investor program that's partnership with the state, it gives an aura of legitimacy and the idea that the government is actually doing due diligence and checking these things. But as I've learned in my life, you can never rely on the government to do that due diligence. They're always going to fall short because they don't have the profit motive and responsibility motive that other people have. If you look at a lot of the mistakes government had, the people who were in charge of the mistake usually got medals instead of being fired or having their names dragged in the mud. So having a government partnership that shows some inkling to foreigners that the government's involved gives them the false impression that their money is safe. And that was a big mistake, and I agree with USCIS. Unless the government is going to really crack down and control the funds or do something that's really not functional in a business market environment, they shouldn't be getting involved. But if they do, that sort of involvement will make them less viable as a business anyway. So either way, government involvement in this process should be limited with regards to giving an aura of legitimacy. Even when they say that a company is a regional center, and I've seen practitioners sell this the wrong way about EB-5 program, and I'm very against it, but the regional center aspect of getting a license gives the perception to foreigners that the government has actually reviewed the business plan to an extent to say that these people are legitimate or not. Getting a regional center certification, for those who don't know, is up till now is simply filing a form and getting it, maybe doing a business plan and all that kind of stuff, an operating agreement, but it's not the most sophisticated document that a person can be relied upon to accomplish what they're saying. Now, with the EB-5 reform stuff, they are increasing that. They're increasing the fees for EB-5 registration of regional centers. But in general, if you look at the SEC, Securities and Exchange Commission, with all the stock market shenanigans and debacles, there's no way to actually crack down on these businesses. And one of the things is I get a lot of consultations on EB-5. I think I get one of the most consultation-rich offices when it comes to EB-5, but not actually processing cases. It stops at the consultation fee because I don't leave them under any illusion that their money is safe, under any illusion that this is going to happen fast with the EB-5, and any illusion that there's some sort of government dad that's going out there watching out for you. I say, listen, it's a business. If you give this money to your brother and your brother starts a restaurant or some other business, what are the chances he's going to give your money back? And they say, well, you don't know. And I say, exactly. It's no different than, frankly, forget your brother. You go into business. It may happen. It may not. That's the risk you're taking. So unless you have millions of dollars and this minimum of $500,000 isn't going to burn you and it's going to affect your life, you should not be doing an EB-5 program. Ideally, if they have a lot of money, they may have a business overseas. They could lead to an L1. Not all these people are business people, though they just have a lot of money. Maybe an E2 if they have a treaty country. But if you're doing EB-5, buyer beware. There are risks involved. There are delays involved. There are unnecessary denials involved as well. And that's just the way it is. And it's really important to be straightforward with clients about the risks on this because you don't want them coming back at you or just waiting 2 years and then getting a denial or the money lost with the expectation that you as the attorney should do something, because this is a potential malpractice lawsuit waiting to happen. Moving on from the news, a couple of office stuff that came up that just came to mind is, first things first, this really frustrates me because a lot of people that are visiting the United States, for example, getting tourist visas, the DS-160 is not something you necessarily need an attorney for. They don't hire lawyers when they want to do that. But foreigners a lot of times, especially if they don't speak English, hire agents or travel agencies to help them get the visa. Those agents go and fill out the DS-160, but because they don't care and they don't have high standards, they fill it out all wrong. Like I have a case right now, applied for a visa for a client who's here now, and we want to do other stuff, but when I was looking at the DS-160, they wrote their address wrong, they wrote the work wrong, they wrote the name of the previous spouse, the date of divorce. A bunch of the important biographic information was completed incorrectly. And now, so if we're going to do a G325A or whatever, I won 30 out of 40. There's all this inconsistent information in the system. Now, we can always explain what happened, but when you fill out the DS-160 online, it asks, has someone helped you? And normally these companies don't write that someone helped them, and they just click yes. And at the end of the day, the applicant is responsible for that false information. So we'll see what happens with it, but it's very frustrating. Foreigners have to get educated that don't trust these people. Review it yourself before submitting it. Don't put such an important thing like your immigration status under jeopardy by just giving it to someone else to do. That's very frustrating because I see this all the time when people file the DS-160 or even other kinds of applications, and someone else does it for them. They don't have a copy. They never reviewed it, and there are severe consequences to that. Another thing that popped up, I think, as always, whenever I get one type of case or one type of call, I get multiples of the same call at the same time. And I've been getting a lot of humanitarian reinstatement cases where we had like a U.S. petitioner, for example, a U.S. citizen father applying for their adult children. Father passes away, but they want to keep the petition alive because they switched up to the mother. Well, there is this kind of humanitarian method where you can substitute a sponsor. From what I've seen, it's extremely difficult to do so, especially if the foreign national is living outside the U.S. at the time. And to get them to, humanitarily change the petitioner sponsor, blah, 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 to do that is extremely hard. I've seen cases where people had the most horrific fact pattern, sad and heartwarming to help them and if you wanted to and all that kind of stuff, and they were denied. So when people come to me for an humanitarian reinstatement, I always couch it in very negative terms, saying we could try it, probably not going to happen. Well, one case came to me like last year or a year or more, and this person had filed for their own humanitarian reinstatement or sponsorship substitute, and they showed me application. They wrote one letter. It was 2 paragraphs. Said, "Please let my brother do this. It's hard living though. I'm going to do this and that." Really basic letter. That's it. They sent it in, and they're like, "We haven't heard back from USCIS in a year. Can you help us?" So contacted the California Service Center. We got a letter back saying, "Yes, you were approved last year. We've been trying to contact you. Please update us on your address because we want to move forward." And that blew my mind to see that was approved. It was kind of offensive because I'd seen so many people with such difficult situations with great evidence and documentation not get approved. And then just jumble things up. And that was a turning point in my appreciation from that and seeing a couple of EB-1 cases that were denied and a couple that were approved that either shouldn't have been approved or shouldn't have been denied at all. I realized if the client can afford it, do everything you can. Put it all on there. It's not about you making money on them and this and that. And be straightforward with them. Be like, risk is high and probably not going to happen. But if you have the money, do whatever you can. There's no point in being cheap about it. And that's one of those things before I'd be like, well, is it worth telling the client to do this because they're going to spend a couple $1,000? Tell them and leave it up to them. Give them full disclosure and then let them decide. If they don't want to work with you, maybe they'll find a cheaper attorney. But it's always good to file whatever you can. And that's something I've come to realize for some years of practicing, is you never know what USCIS is going to do. Now, in that humanitarian statement case, so we contacted California Service Center. They said they could send us more information. A year goes by, they still don't send us the information. Client disappears, and I lost track of it. But although they said they approved the case for substituting a sponsor, still nothing has moved forward from what last I heard like a few months ago. So just because they approve it doesn't necessarily mean it's going to happen either. Maybe they looked at it again and realized how ridiculous that was. Another point, and hopefully this isn't too controversial, but the American Bar Association, the ABA, had an article out that said that their take on having people that don't have lawful status in the United States but are becoming attorneys is that they should be permitted to be able to practice law in the U.S. And it's an interesting thing. I mean, these people, a lot of them, are DACA type cases where they were born here, raised here, they want to practice law, they went to law school. But is it right to have someone who technically is in violation of law being an attorney practicing the law? And then on the other hand, because these people's status is unknown and could be issued at any time, how good is it for a case, for example, even if they become immigration attorneys, they start a removal proceedings, they can't go to removal court. Or they start something that's USCIS based and they go to a marriage case and they get picked up at the interview. Or anything, in the middle of a case, doing a waiver, they get picked up. And that sucks because it puts a lot of pressure on them. But at the same time, what happens to that case if your attorney all of a sudden disappears because of a lawful violation of the law? Now, an attorney could always just die in the middle of the process. They could get sick. There's always a backup solution to this kind of stuff. So I don't want to be as harsh and say they shouldn't. But what is the responsibility of the bar to the standards of who could join it. I don't want to be one of those people who join a group and then tries to kick it and want to make it harder. This has come up a lot in California because there's talk about lowering the bar passage rate so that particularly more minorities could come and join, because they're apparently, according to their statistics, minority groups are less successful in the bar. But if we lower the score, there'd be higher percentages of them, and it would increase diversification in the legal field. I, along with 80% of the California bar membership, said that's ridiculous. You can't lower the standards to help people in. But I do appreciate what they're saying that is like that. But at the same time, I know so many attorneys that came to the U.S., especially in immigration law, when they're 18, 19, then without speaking a word of English, and they worked their butt off, and within 5 or 6 years, they were able to pass the bar the first time around. So the idea that someone's raised here and their standards aren't high, we have to lower the standard, it's offensive to those that came as adults. And there's a lot of people, especially in immigration bar, that came here as adults, learn English as an adult from Iran, Brazil, Russia, China, and passed the bar. And it really is kind of offensive to them to say, like, it can't be done when they do it. You just got to work harder. But, it's one of those things that can offend a lot of people. But at the end of the day, we can't lower standards just to do it. We see that a lot in high schools in America, where we just start graduating people based on attendance rather than actually passing the course, because the idea that it makes them feel inferior for not being able to keep up with everyone else. But how about, like, making the system better or working with their families somehow, rather than just giving a false piece of paper that totally devalues it in everyone's eyes? Now, California bar has always been one of the harder ones, but I always took pride in the fact that the California bar is one of the hardest, and attorneys to do that. Having said that, there's a lot of garbage attorneys here, so maybe the bar exam itself is not the best indicator of quality when it comes to law. But if it's a system we've had, lowering this system that's already flawed to a lower level, it may not be the best thing to do. But maybe I'm wrong, I don't know. The last thing I want to talk about is something that comes up probably for everybody who's listening to this. It's the idea of co-counseling with other people. When I learned immigration law, I did a lot of EB-1s and EB-5s and Ls, these complex areas which a lot of people don't necessarily do. And it's funny, like the really easy stuff, like I didn't do this hard stuff, so I'm more comfortable with them than other areas of immigration law. But it comes up every once in a while where people contact me wanting to co-counsel with me on stuff. And I've never been able to do it because I'm not really sure how to co-counsel on something like that. It reminds me of when I was in high school and we would do group science projects, for example, and we have a group of 4 or 2 people. And whenever I was in these groups, either I'll do all the work or I'll just leave and not do any of it, someone else would do it. That cooperation of doing partial work here and there never was possible for me. I'm not sure, maybe other people are more group-oriented and team member-oriented, they could do that. But when I look at an immigration case, I get so deeply involved with the client and the case, I don't see how I could be doing half the work. If I'm doing EB-1, I'm just doing it. If you're doing something, you're just doing it. I can't give half the work to someone else. It could be a situation where I talk to the client and the other person misses something, or they talk to them, they don't share information with me, and I miss something. So it just seems like a risky thing for the client to do, even as co-counseling. I appreciate everyone who's asked me to do that. It shows like respect, that they respect me enough to trust me with their client and to come with that case. So this isn't anything negative about that. I really appreciate that. But just practically speaking, I just don't know how to do it. So it'll be interesting. If you do co-counsel stuff, please email me. My email is info@jqqlaw.com with your experiences, whether you do it again, how you've made it work. I don't have a problem with giving some sort of a referral fee or like a cooperation fee with regards to the case. And if the client permits it, let the attorney see the final version of the case so they can learn from it. Or if they want to be the client's liaison, reviewing my work as it's going on, that's fine. I always appreciate a second pair of eyes. But to do it together in the sense that payment's 50-50, especially when I feel like I'm going to do 99% of the work, it just doesn't make sense in my schedule just to make a little bit of extra bucks to do a service to the client on one end. And second is get paid much less than I would on a case that's so in-depth and time-consuming, like an employment-based immigration case. So it just happens a lot, and I see a lot of people ask for this. That'd be an interesting thing. I'd be interested to see how you've dealt with this. So please email me, info@jqqlaw.com. I guess last thing is I'm creating an immigration education system for immigration lawyers to learn more about how to practice and what I do. And it's going to be set in separate modules for family and employment-based and how to practice management phase. I think I'm going to do the practice management portion first. And I'm going to really break down exactly what I've done, how much money I've made, how much my costs are, all those details for you. It's going to be a premium service, so it's going to be a paid video thing and with written material coming out. But I was interested, if there's any particular things about my practice you're interested in, please let me know. I can add it to there, or any ideas like that. I'm going to make it very transparent so people who are interested in immigration law or want to do more of it or full-time practice it, see exactly what I did, and I've become fairly successful, and things are working very smoothly for me and just growing really sharply. So I want to share with people how to do that because it's not too difficult. And I think it's doable for a lot of people. So if you had any questions about how I did any particular stuff, as detailed as you want, let me know. And to the extent I can, I'm going to have that prepared in the program for you. Thank you so much for listening. Sorry I didn't make it last week, but I've been contacted by so many different people, new people that are watching the program, listening. The downloads are up. Thank you so much for listening. Always feel free to contact me. This is it for this week, but I look forward to the next one and hopefully be pumping out more material. I have even more ideas. Now that the move is settled in, I'll be able to pump out more stuff faster. Thanks so much. Until next week, have a great one.